First District Court of Appeals now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have one case on the docket scheduled for oral argument this afternoon, the case of Detroit Tigers, Inc. versus Fathers. Counsel ready to proceed?
Yes, Your Honor.
You may approach counsel. Counsel allocated 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
5 minutes, Your Honor.
So noted, Madam Clerk. You may continue, counsel.
Okay, thank you, Judge. Thank you, Your Honors. May it please the Court. My name is Rich Irvin, and I'm here on behalf of the Detroit Tigers and Sedgwick. And appellants respectfully request this Court to reverse the JCC's decision below. The average weekly wage that calculates $370.36 was improper because the wage was more than twice as much as what the claimant could have made under the employment contract. The case law is very clear under 440.14 sub D, and moving back to the legal questions of this case should be reviewed de novo because any deference to the JCC with respect to the interpretation of the employment contract is a legal question rather than abuse of discretion. Alternatively, if this court were to review it under an abuse of discretion standard, reversal is still required because there is no competent substantial record evidence to support an AWW of $370.
Well, let me ask you about that, counsel. I'm looking at Record 92, the Addendum C to the minor league uniform player contract that says his monthly salary is $1,500 a month. So, I mean, doesn't de novo, abuse of discretion, whichever one, doesn't that provide CSE for the JCC's finding?
It doesn't, Your Honor, because it's a miscalculation, misinterpretation of what that addendum says.
Well, let me give you a hypothetical. So I'm a teacher. I've got a 10-month contract. 2 months of summer are mine to do what I want. I can work. I could lie on the beach 2 months, whatever. First day of working on my $60,000 a year contract, I hit my head and I'm going to be out for a year with a concussion, right?
Correct.
So do you owe me just the 10 months or do you owe me the 12 months with a salary prorated for the whole period?
It's the prorated amount for the entire year because the contract's for the entire year. So under your example, if the teacher were paid $60,000 per year and she took 2 months off, or he took 2 months off for the summer, for instance, it's still $60,000 for
Well,
the entire
but
year.
the monthly salary, though, is $5,000. Well, I don't know what would be. For 10 months, it would be $6,000 a month, right? So $6,000. So there's 2 months where he wouldn't normally be working under the contract, but he would be able to work on his own or not work on his own. Wouldn't the teacher in my hypothetical be entitled to a wage for those 2 months?
It depends. It depends what the contract says. And your hypothetical, if he was still under contract and he can go off and attain other employment during those 2 months that he's off, he has the right to do that. If
Well,
it's
so
approved by-
and the player here, I mean, I know there's some restrictions on it, but he can, you know, he could have gone and been a, you know, travel baseball coach or something like that during the off season, right?
Correct. Yes.
So I'm not following you then. It seems like you're agreeing with me that if he's able to work during that off period of time, he should be paid for that off time, right?
Well, here's what the case law says. It says that if he is able to work and he does work and he does get a wage for working during that time, then it can be included. And we do concede that if he were working during that time and there was evidence of how much he was being paid, that would be included in his wages. But here in these facts, we don't have that. There is
Well, that would be the case if we were calculating it under 14.1C, right, as a seasonal employee, if we were going to include maybe other employment and kind of build it all together? Is that what you're suggesting?
Yes and no. So seasonal employee under sub C is a retrospective application. It takes into consideration the 52 weeks. So yes, in the fact that it takes into account the entire calendar year, I would say yes. However, you also have to take a look at whether or not he was actually earning a wage during that off time. Here he wasn't. Here he said, the record is very clear, his deposition transcript, which was admitted into evidence, he says he was never earning a wage during the off season. And all we have on the record is what his actual wages, earnings were.
Right, so meaning if he had been working in the off-season, then he would have been free to make an election under 1C and have that income included in the calculation, but he wasn't and didn't elect to proceed under 1C. Right?
Yes, Your Honor, that is absolutely correct, yes. And so we would concede if there was some sort of employment during that off-season that it would be included, but he never worked during the off-season. What we have is in 2018, he was making $7,400 for the calendar year. Now, that was paid out over a 5-month period during what they call the championship playing season. The championship playing season starts in April and goes all the way through August or September, depending on the schedule. Here it was from April all the way through August in 2018, and that's the period of time that he was paid. So if you look at it in totality throughout the entire year, it's $7,400, not $1,500 a month. For 12
Doesn't the
months.
JCC have some discretion to try to craft a fair and reasonable amount under 1D?
He does. He does have discretion to do that, but that discretion is not unfettered. It has to be within the bounds of the case law and the bounds of the statute. And what our case law says out of this court is that you have to look at either, number one, a contract of employment, or number two, the actual earnings. Now, here we have a contract for employment, so what the case law says is that if you read, I guess, between the lines of the case law, he says you look at the contract first, and if that's clear enough to be able to determine a wage, then you use those terms. If you can't, then you move on to the actual earnings.
Counsel, you indicated that 440.1D gives the JCC discretion in determining the AWW. In that case, why should not our standard of review be abuse of discretion?
For two reasons, Your Honor. Number one is he does have discretion. However, that discretion has to be confined to what the contract interpretation is. And under the case law, anytime that there's a contract interpretation, it's de novo review. So it's our position that it should be, if he misinterpreted the terms of the contract, it should be reviewed under de novo. The second point under de novo review is that it appears that the JCC was struggling, I guess the right word is struggling to be able to apply this prospectively. And so what the cases say under prospective application is that it has to be within the terms of the contract at the time that he was injured. So you can't look beyond the contract into different work outside that period, which it appears that the JCC did in this case. You can't look to what he was making when he was a sales rep at Experian because our client never bargained for that wage. It was never
But I mean,
bargained.
that wasn't included as his wage, though, was it? Didn't the JCC use the $1,500 a month for, even the months that weren't part of the championship season?
He used it, yes, for
He
the
didn't use
entire year.
Right, he didn't use like the $58,000. That would have been substantially more than the average weekly wage that he came up with.
He didn't use that wage, but he compared it to that wage, and he said his reasoning was that because he was making $55,000 or $58,000 as a sales rep, that this is justifiable in that instance. So it's our position that he improperly applied it prospectively. The cases say when you look at prospective application is that there has to be some sort of entitlement to any additional wage that you have out there that you can incorporate into the AWW. For instance, there's one case that says that a person was entitled to a wage. He was, entitled to a raise. The raise wasn't received at the time that he was injured. Nevertheless, he was still entitled to that, and so this court said that that should have been incorporated into the AWW.
Are we looking at the 2018 numbers? That's what the JCCA applies, right? The 2018?
2018, yes.
And so we have the contract that indicates the amounts for 2018, and we also have payroll and testimony about what was actually received during 2018, right?
Yes, sir.
Is there any discrepancy between those two? It looks to me like they're the same, that the amount paid was the same as what's contemplated under the contract.
Absolutely correct. They match up perfectly. So if you
So my point in asking that is so when we're looking at 1D and a calculation under 1D, and the Supreme Court tells us, well, you're to look at the actual amount or the contract, those amounts are the same here.
Those amounts are the same. If you take a look at the pay frequency versus what he earned, you take a look at the pay frequency is 5 months out of the year, not the entire year. If I want to change the facts for a second, suppose he was paid $7,400 one-time lump sum per year, it wouldn't be right for the JCC to take the $7,400 number and divide that by 4.2. In the same instance as we have here, it would be just as wrong for him to take the $1,500 number per month and divide that by 4.2, because under either scenario, our client never paid that much under the contract. The most my client paid under the contract was $7,400 in 2018. Now, in 2019, our client, he never played.
Counsel, you're well into your rebuttal time.
I'd like to reserve, Your Honor, if I could. Thank you very much.
May I approach counsel?
Your Honors, may it please the court, I'm Mike Weiner here on behalf of the claimant/appellee Austin Sodders, and we thank you for your time today. This is a very important issue, as Judge Bilber, you've seized upon. It's not just how we're going to treat all the minor league baseball players. There's also minor league hockey players, other professional athletes, but also teachers, other people who only work part-time out of the year or during a certain season out of the year. And, to borrow a bad baseball metaphor, I would suppose, there's really three strikes in terms of the employer-carrier's argument, and we don't need to have all three strikes. They're really out on any one of the three arguments, but their argument fails for three different reasons. Number one, they've got a substantial preservation of error problem here, right? Everything the record is absolutely clear. There was no motion for rehearing that was ever filed in this case. And this case has said it over and over again in a variety of different cases, most recently, I think, and most emphatically in the Hamilton versus R.L. Best case, that preservation of error requires that a motion for rehearing be filed when the error or the alleged error of the judge first appears in the final order. Well, the error of the judge of compensation claims here is first made in the final order. And for whatever reason, appellants did not file a motion for rehearing on that issue. Now, they're asking this court to reverse the JCC for an error that the JCC allegedly never even had an opportunity to correct. In other words, this mistake that he made was never even brought to the judge's attention to give him an opportunity on a motion for rehearing to correct it. And so the first and fatal strike that the employer carrier has here is one of preservation of error. You had to preserve your arguments for meaningful by presenting them in a meaningful way before the judge of compensation claims. We've argued it in our brief. There's, I think, 8 or 9 different cases that they're now citing in their briefs that were never even mentioned at any point in time before the JCC. And the case fails as a result of preservation of error and not filing a timely motion for rehearing. Number 2 is appellants have argued the wrong standard of review. This court has held for years. Judge Lewis, I think it was over 20 years ago, you were on a panel in the case of Able Body versus Lindley. And you authored an opinion where you recognized the appropriate standard of review when you're dealing with Section 440.14. 1 subparagraph D is abuse of discretion. They do not argue abuse of discretion anywhere in their briefs. The only thing they come to somewhere close in the reply brief to say that the judge didn't abuse the judge abused his discretion because competent substantial evidence didn't support his findings. And I'd submit to you that's conflating really the two standards. They were responsible to argue the appropriate standard of review to this court. And standard of review matters. And we talked about this in our brief in the North Florida Women's Health and Counseling versus State case, a Florida Supreme Court case that talks about an appellate court's first obligation when reviewing a lower court's decision is to articulate the appropriate standard of review, because that establishes what the rights of the parties are. And if you don't adhere to the correct standard of review, then you may tilt the playing field irreparably and prejudice a party's rights. Okay, so what does that mean in the context of this case here? The employer carrier had the responsibility to argue this case under a standard of review. That is the most deferential standard towards the judge of compensation claims. They were obligated to establish in their briefs that no reasonable person could have taken the view that judge of compensation claims took on that case, and that the judge of compensation claims view was arbitrary or fanciful or unreasonable. And I would submit to you that they just cannot meet that standard, and that is the proverbial strike 2 of their argument. And strike 3 really just goes right to the merits of it, right? Let's contract as it's written. In this case also there was a stipulation that 440.141D is what applied. And so what the judge here has looked at that contract and said, well, the contract, page 92, very clearly bears it out, right? It's the claimant gets paid every month.
So let me ask you this. What am I to make of this sentence? I'm looking at the JCC's order on page 6. It says the claimant should not be restricted to the terms of the contract under which he played, despite its control over the claimant's activities for the entire year. What are we to make of that? That sounds to me a lot like he's rejecting the contract that he's required to abide by.
Well, I would suggest to you that even if the judge did do so, that it is sort of a red herring. It's meaningless, because we know that the judge arrived at the correct result. The result is A, supported by competent substantial evidence, B, that it was supported also by the actual earnings of the claimant. So, and I don't know that that language necessarily indicates that the judge was completely disregarding the contract at all. I think what the judge, as I read the order, what he did is say, well, slice it up any way you want to slice it. Whether I use the contract, whether I use his actual wages, I'm going to get to the same number, because what was he earning? He was earning $1,500 per month. That's what the major or the minor league contract that he operated under specified that he would earn, and what he in fact did earn, both according to his own and the adjuster's testimony. So, in closing, Your Honor, there is absolutely no legislative text. There's no plain language of the statute that supports the employer carrier's arguments in this case that we should take this gentleman's wages and divide them by 52 to arrive at an average weekly wage. That calculation is not one that is fair or reasonable, because it represents, as the judge noted in his order, I think the judge said 45% of what his contracted monthly salary was. And so for those reasons, as well as for having not articulated the appropriate standard of review, and as well as for not having preserve these errors properly for appellate review, the claimant would respectfully request that Your Honors affirm this case. Any other questions?
Thank you, counsel.
Thank you, Your Honors. Just as rebuttal, just want to touch on a couple of things that my opponent brought up. The preservation of error, this issue has been squarely before the JCC. It's been thoroughly litigated. The only issue before the JCC was what the correct AWW was. There's really no other issues outside of that. The case law was presented. Now, we might not have presented all the case law that we cited in our brief, but we're not required to. The purposes of appeal is to take a look at this issue and do thorough research into the case law and bring those cases about. And I believe Judge Padovano in his treatise said that it's not necessary to cite every single case law out there at the lower level. As far as the motion for rehearing, the purposes of that is for issues that have been ruled on by the JCC in its order, but never addressed at the hearing. So it's our position that a motion for rehearing wasn't necessary. Going into Mr. Weiner's analysis regarding pay versus earnings, I think that's what this case boils down to. It's really, are you supposed to look at the pay and the frequency of the pay, or you look at the earnings? Well, we know the answer to that is found under 440.02 sub 28, and it says that in terms of what is earned rather than what is paid is the standard. And consistent with this and taking into account the pay frequency. So the AWW here does not take into consideration what he earned throughout the entire year. It takes into consideration his pay for a very limited point of time, which is 5 months during the year. However, he earned that salary of $7,400 throughout the entire year. And Judge Long, I think you pointed on this, he had other duties that he was supposed to do other than just playing those games during the 5 months. He had expedition games that if he was called on to do that he was supposed to do. Other things that covered that salary, just not playing in those games. So when you take a look at the terms of the contract, which I don't believe the JCC did, thoroughly read those other obligations under the contract, but when you consider those are all things that are covered under his $7,400 wage. So when taking a look at the contract and you take a look at the 2018 pay stub, it becomes clear that the most that he was entitled to earn under the contract in 2018 was $7,400. And looking beyond that, looking to what he made, say, when he was working for Experian, that's error as a matter of law under the case law. So with that, if there's no further questions, I think I'll conclude. Thank you.
And thank you, counsels, for your respective oral arguments this afternoon. This concludes our oral argument this afternoon, and we stand adjourned.
All rise.